But going again back to a role you spoke about, determining the applicable law for arbitration, but I would like to understand what role could BIL play in determining the applicable law for arbitration agreements, which could be also involving multiple jurisdictions.
Okay, so imagine that one has a contract governed by English law with an arbitral seat in France, and issues arise as to the existence or validity of the arbitration agreement. What law governs that arbitration agreement? Is it English law because the parties chose English law to govern the underlying contract? They have a choice of law clause in their contract that provides this contract shall be subject to the laws of England and Wales. Or is it French law because the parties chose to seat their arbitration in France? This is actually not a hypothetical. This is a real case. It's a case called Kebab versus Kout Food Group. And it was decided both by the UK Supreme Court on the one hand and the French Cour de Cassation on the other hand. They reached opposite conclusions. The UK Supreme Court, consistent with at least some UK authority, not in my view the better reasoned English authority, but some English authority, concluded that a general choice of law clause applies also to the autonomous arbitration agreement. In contrast, the French Cour de Cassation, in an action to confirm the award made in Paris, made in France, reached the opposite conclusion, reached the conclusion that the arbitration agreement was governed by the law of the arbitral seat. That means French law, and in particular, French international arbitration law. And thus, that case is a very good example of how different courts, applying their own PIL rules, reach different conclusions with respect to the law governing the arbitration agreement. Importantly, there's a happy ending to that thus far unhappy story in Kebab. The happy ending, perhaps not for Kebab and Kout Food Group, but for the international arbitration world more generally, is that the UK Law Commission recommended overturning the decision in both Kebab and an earlier case called Inca versus Chubb Insurance Company, and providing that absent an explicit choice governing the arbitration agreement itself, explicit choice of the law to govern specifically the arbitration agreement, that agreement would be governed by the law of the arbitral seat, not the underlying contract.